Welcome back to Real Talk Behind the Badge. I'm Tim, a retired police sergeant, and I'm talking to you from South Carolina. This is my 8th podcast, and you can watch each one at realtalkbehindthebadge.com, on Facebook, or on YouTube. Today, we're going to talk to you about detainments and searches. I want to address some items I've been watching on YouTube that deserve some scrutiny. So let's get going. First off, all officers should wear a body camera and have it on whenever approaching a civilian. This is for the officer's protection and the civilian's protection. I can't count the number of officers that have been falsely accused of a crime and the camera absolved them of all wrongdoing. But you got to remember, that can go both ways. Detainments. For a law enforcement officer to detain a person, specific legal requirements must be met under the Fourth Amendment, which protects against unreasonable seizures, and a detainment is a seizure. The standards primarily stem from Terry v. Ohio in 1968 for brief investigative detention, and they usually call those Terry stops. Now, the officer must have reasonable suspicion that a person is involved in, has committed, or is about to commit a crime. This requires specific, articulable facts based on objective observations, not just a hunch or a gut feeling. I can't count the number of detentions where the officer justified a detention on just plain suspicion, without a specified crime. That is not lawful. Now, the detention must be brief and limited to investigating the suspected criminal activity. The officer can ask questions, check identification, that's in some states, or verify information to confirm or dispel their suspicion. The stop must not extend beyond what's reasonably necessary unless new facts justify further detention or escalation to an arrest. Now, the detention must occur in a public place or where the officer has a legal right to be, like during a traffic stop, a pedestrian encounter, or responding to a reported crime. If the detention occurs in a home, additional requirements like a warrant or exigent circumstances may apply. The stop must be brief, typically minutes, not hours, though courts haven't set a strict time limit. Unreasonable delays can violate the Fourth Amendment. In the United States v. Jones, 10th Circuit Court, 2012, the stop extended beyond 14 minutes for unrelated questioning and was deemed unreasonable without a new suspicion. Let's talk about pat-downs. For a law enforcement officer to conduct a pat-down, also called a frisk, of a citizen in the United States, a specific legal requirement must be met. The standards also stem from Terry v. Ohio, and here's a breakdown of what's needed. The officer must have reasonable, articulable suspicion of a crime that is about to be committed or has been committed, that the individual is involved in criminal activity or poses a threat to safety. This is a lower standard than probable cause, but requires specific, articulable facts, not just a hunch. An officer may not pull up on a person without the facts I just articulated and pat them down just for officer safety. The pat-down is limited to a search for weapons that could endanger the officer or others. It is not a full search for evidence unless further justification like probable cause exists. The officer must reasonably believe the person is armed and presently dangerous and must be able to articulate this. 99 times out of 100 videos I've watched, the officers had no reasonable, articulable suspicion the person had a weapon on them. They just said they wanted to be sure, which is not the standard. Whether this is due to poor training or just intimidation, I don't know, but I believe most of the time they're just trying to show who's in charge, and this is very poor policing. Now, the frisk must be confined to a pat-down of outer clothing to feel for weapons. If the officer feels something that is immediately apparent as contraband, they may seize it. but they cannot manipulate objects to identify them unless they suspect a weapon. Now, the pat-down typically occurs during a lawful investigative stop, the old Terry stop, where the officer has reasonable articulate suspicion of a crime to detain the person briefly. The stop itself must be justified before a frisk can occur. If the citizen voluntarily consents to the pat-down, the officer doesn't need reasonable suspicion, but consent must be clear and uncoerced. If the officer exceeds the pat-down's purpose, like searching pockets without justification, it may violate the Fourth Amendment, potentially making any evidence that they find inadmissible in court. Documentation. I believe this is important. States and departments should have a law and policies in place that officers must document the reasons for each stop and frisk, and it must be enforced. No more frisking for intimidation tactics. This should especially be enforced in jurisdictions with policies to address concerns about racial profiling or overuse. Supervisory review should be standard for each stop and frisk. A full personal search, where a law enforcement officer thoroughly searches a person's body, clothing, and belongings, this is beyond a limited pat-down or frisk, requires stricter legal standards under the Fourth Amendment. The officer must have probable cause to believe the person has committed a crime or is in possession of evidence, contraband, or items related to criminal activity. Probable cause is a higher standard than reasonable suspicion and must be based on specific objective facts. Here, I've observed many officers going into the pockets of detained people just to get their identification. This is a search and is not justified unless probable cause is present. Any officer who violates this requirement must be taken to task with training and/or punishment. Now let's talk about when you may search. The safest way is to get a search warrant issued by a judge and is generally required, specifying the person to be searched and the items sought based on probable cause. The exceptions are incident to an arrest. If the person is lawfully arrested based on probable cause, officers can conduct a full search of their person and immediate surroundings to ensure safety and preserve evidence. Consent, of course, if the person voluntarily consents to the search, no warrant or probable cause is needed, but consent must be clear, informed, and uncoerced. Exigent circumstances. Urgent situations, such as immediate danger or risk of evidence destruction, may justify a warrantless search. If contraband or evidence is immediately apparent during a lawful stop or pat-down, it can justify a broader search. Now, the search must occur in a lawful encounter, such as a traffic stop, investigative detention, which is a Terry stop, or an arrest. The officer's initial reason for detaining the person must be legally justified, or the possibility of everything being thrown out in court. Documentation, again, this is very important. States and departments should have a law and policies in place that officers must document the reasons for each search, and it must be enforced. No more searching as an intimidation tactic. Supervisory review should be standard for each search. This should especially be enforced again in jurisdictions with policies to address concerns about racial profiling or overuse. Cities and states will continue to pay out large sums of cash to those who have been violated if this is not accomplished. Vehicle searches. In the United States, a law enforcement officer can search a vehicle under specific circumstances. The rules balance public safety, law enforcement needs, and individual privacy rights. Officers must have probable cause, not suspicion, to believe the vehicle contains evidence of a crime, contraband, or fruits of criminal activity. Probable cause requires specific objective facts, not just a hunch or suspicion. The search can extend to any part of the vehicle where the suspected items could be including the trunk, glove compartment, or containers. That's Carroll versus United States in 1925. And it's held ever since then. Usually, no search warrant is needed due to the automobile exception, which is the Carroll versus United States again, which recognizes vehicles' mobility and reduced privacy expectations compared to homes. If a person in the vehicle is lawfully arrested based on probable cause, officers can search the vehicle's passenger compartment, including containers, to ensure officer safety or prevent evidence destruction, but is limited to the area within the arrestee's immediate control. It's like the seats, the center console, and only if the arrestee is unsecured and could access the vehicle, or officers reasonably believe the vehicle contains evidence related to the crime of arrest. If the arrestee is in handcuffs, there is no reason to search for officer safety. If an officer, while lawfully present, such as a traffic stop, sees evidence or contraband in plain view inside the vehicle, they can seize it and potentially justify a broader search. In urgent situations where there's no time to get a warrant, officers can search if there's probable cause and immediate action is needed to prevent evidence destruction, protect public safety, or pursue a fleeing suspect. During a Terry stop, if officers have reasonable suspicion that a person in the vehicle is armed and dangerous, they can conduct a limited frisk of the passenger compartment for weapons, but is restricted to areas where weapons could be hidden and only for officer safety, not evidence. Passengers can be detained during a stop if there's a reasonable suspicion, and their belongings may be searched under the same condition as the drivers. Now, that's a lot to understand, but it's very important. Let's talk about canine searches. A law enforcement officer can conduct a canine search on a vehicle, person, or property under specific circumstances. The rules depend on the context, most commonly vehicles during traffic stops, and that's what we're going to talk about. When can a canine search be conducted based on key legal precedents? A canine sniff of a vehicle's exterior is not a search under the Fourth Amendment, so officers don't need probable cause or reasonable suspicion to conduct it, provided the sniff doesn't extend the stop duration. That's Illinois versus Cabela's in 2005. But again, in United States versus Jones, 10th Circuit Court 2012, a stop extended beyond 14 minutes for unrelated questioning was deemed unreasonable without new suspicion. The same would apply for canine searches without probable cause. Now, the traffic stop must be lawful. The sniff must occur within the time reasonably required to complete the stop's purpose, like issuing a ticket or checking a license. Extending the stop beyond this without reasonable suspicion of criminal activity violates the Fourth Amendment. Again, Rodriguez versus United States, 2015. And again, United States versus Jones, the 10th Circuit, 2012. The dog sniffs the exterior of the vehicle. If the dog alerts to drugs or other contraband, this provides probable cause for a full vehicle search under the automobile exception without a warrant. If officers have reasonable suspicion or probable cause that a vehicle, person, or property contains contraband, they can deploy a canine to confirm or dispel their suspicion. In public places like airports or bus stations, a sniff requires no suspicion if it's minimally intrusive. Now, sniffing a person directly may require reasonable suspicion or consent, as it's more intrusive. If a person is lawfully arrested or a vehicle is impounded, a canine sniff may be conducted as part of a broader search or inventory process. If the vehicle is searchable under Arizona versus Gant, 2009, For evidence related to the arrest, a canine can be used to locate contraband. For a canine alert to establish probable cause, the dog must be properly trained and certified. Courts can scrutinize the dog's accuracy if challenged. For traffic stops, a canine sniff must not unreasonably prolong the stop unless there's reasonable suspicion. Again, that's Rodriguez v. United States, 2015. In a traffic stop case, the court ruled that extending a stop beyond its original purpose, like issuing a ticket, without new reasonable suspicion, violated the Fourth Amendment. A 7 to 8 minute extension for a dog sniff was deemed unreasonable, absent additional justification. So even a 7 or 8 minute extension for a dog sniff, the court found was unreasonable. Although a court has stated that a canine search outside a vehicle is not a search under the Fourth Amendment, it should not be used unless there is reasonable suspicion. I believe canine officers must document each search with the officer's name who requested the search, why the search was requested, and the result of the search. Officers who continuously request searches that continuously result in no results should be denied canine searches without a superior officer's consent. A superior officer must also agree with and document the officer's reasonable suspicion. This will also cut down on officers who say they smell an odor of marijuana just as a pretense for a search. I also believe that it would be a reasonable and good public relations for a canine handler to inform the person whose vehicle is being sniffed of how the dog will react if it alerts on the vehicle. The person should also be allowed to view and video the search from a safe distance. This will help alleviate a person's suspicion that the handler is just saying that the dog alerted. So there you have it. Make sure to hit the subscribe, share your thoughts, and let's keep this conversation going. This podcast is ground zero. I'm not here for theories or to hear myself talk. I want some real answers and input from officers who've walked the walk. You, me, my brothers and sisters in blue, let's cut through all the bullshit. Academics can keep talking all they want, but we have to build the cure. So join me at realtalkbehindthebadge.com. If you get a chance, drop your state, department, active or retired, what you've seen and what solutions you have in mind. The answers are out there. We just need to find them. Let's hash out the hard fixes, stuff we can shove in front of lawmakers and make stick. We're just starting this journey, and we'd be pleased to have you join us. Your voices fuel this. If anyone has answers you'd like to share, drop us a line, and if you'd like to be a guest on our show, let me know. Go to realtalkbehindthebadge.com. That's realtalkbehindthebadge.com, and drop a comment or a rant. And if you can, drop a couple of bucks to help us out and keep this going. This podcast stuff ain't cheap or easy on a cop retiree's salary. Now you can view our podcast on YouTube, Real Talk Behind the Badge, as we make them. If you hit subscribe, you'll be notified of each podcast. Please hit the like button also. We're also on Facebook at Real Talk Behind the Badge or at realtalkbehindthebadge.com, where you can also view all our podcasts. Thanks to all of our brothers and sisters behind the badge. Keep it going and we'll get this fixed. Stay safe. This is Real Talk signing off until next time. Thank you and be careful out there.